The child support guidelines were put in place to make child support easy, predictable, and fair. They're supposed to result in separated parents spending as much on their kids as they would if the family was together. Yet, child support remains very controversial. Some of that is due to misinformation, like the belief that the government gets a cut of child support. It doesn't. But more often it is because people get child support wrong. So in this episode of the Ontario Family Law Podcast, I am going to go over some common child support mistakes. I'm John Schuman, a certified specialist in family law in Ontario with extensive experience assisting clients with high or complex incomes. I'm also a mediator, arbitrator, and collaborative lawyer. I have a best-selling book, The Guide to the Basics of Ontario Family Law. The new 5th edition has up-to-date information on all common family law issues and lots of information about child support. It is available on the iBookstore, Amazon, and in fine bookstores. My book goes over child support and all the other common family law issues in some detail. So if you need to know about child support, it is a great place to start, as are audio episodes 10 to 13 of this podcast. But to avoid problems, let's go over some common mistakes. Getting the child support amount wrong. The child support guidelines are supposed to make calculating the right amount of child support easier. As I went over in episode 89, the child support tables cover every income level, no matter how high, and child support does not have a cap. Every parent who has the children with him or her at least 40% of the time or more gets child support from the other parent or parents based on those tables. In shared parenting situations where more than one parent has the children more than 40% of the time, each parent pays the base amount of support to the others. You can either pull up the tables and do the calculation of what child support should be, or there are some online child support calculators that will give you the correct numbers. However, the simplest option for parents who do not have shared parenting, the child support parent or parents are not self-employed and earn less than $150,000 per year, and where the children are under the age of 18, yes, child support continues after age 18, see episode 54, is to use the Ontario government's online support and recalculation service. Both parties need to agree to use it, and both need to agree to allow the service to access their tax returns. But when both parents agree, the online service will calculate the appropriate amount of child support and also some basic Section 7 contributions and tell the FRO what to collect. And best of all, no lawyers are required. If your income is more complicated than the online service will handle, you need to check with a family lawyer to make sure it is right. There are some legal issues that require input from a lawyer, which is why the online service won't do the calculation or adjustments. Not making the Schedule 3 adjustments. Child support is usually calculated using the total income on the payer's tax return, but there are several adjustments that can be made. Some of these can reduce the amount of child support. Many of these reductions are found at the end of the child support guidelines in Schedule 3. There are many deductions from income that reduce the amount of child support, and a few that increase child support. These adjustments are the law, so parents are supposed to make them. Not making these adjustments results in the wrong amount of child support. Assuming that child support is always based on total income on a tax return. The starting point for calculating child support is always total income on the payer's tax return. But in addition to Schedule 3 adjustments, the payer's total income can be adjusted, sometimes by a lot, if that payer does not earn most of his or her income through a salary. Payers who are self-employed or earn their money through investments or other ways that are not taxed the same way as salaries can find that there are big upward adjustments to their income, resulting in much higher child support. I went over how that works in episode 76, and even more detail in my book. So check those out if you or the other parent earn a lot of money that is not from a salary. Not exchanging tax returns and adjusting support every year. Sending your tax return to your ex every year can be a major inconvenience and feel like an invasion of privacy. But it is important to do it every year while child support is payable. That's because when one parent withholds income information, a judge can adjust child support up or down retroactively, going back many years when the judge thinks that the parent has forgotten to send his or her tax return to hide a change in income. When a parent falls behind in support, or a judge orders that the parent is behind in support because that parent did not provide his or her tax return, the outstanding amount can be huge, and then the FRO can take half the support payer's paycheck to collect the back payments. That can cause some serious financial problems. That's even before a judge orders one spouse to pay the legal fees of the other spouse on top of the back support. A judge might do that if the judge thinks that by holding back the tax returns, the parent was hiding something. Child support is the right of the child. Judges don't like parents who shortchange their children. So in addition to paying back child support, the judge can order the defaulting parent to pay the other parent's lawyer's bills as well. And all of that will survive a bankruptcy, resulting in years of financial troubles. If you find this episode helpful and informative, make sure you subscribe to keep up to date with family and children's law issues. Hit the like button because that helps us make more episodes, and also click on the notification bell to find out as soon as future episodes come out. Adding or not adding the right Section 7 expenses. Special and extraordinary expenses, or Section 7 expenses, are additional expenses that parents have to pay for on top of base child support. Separated parents share the cost of these expenses in proportion to their incomes. But a common mistake that I see is parents sharing expenses that are not expenses under Section 7 of the Child Support Guidelines, or not sharing expenses that they should. I covered this in a lot more detail in my book, and I give examples of what types of expenses are shared and what are not. So if this is an issue for you, you should get a copy. Special expenses, which are usually shared, are daycare expenses, but only so a parent can go to work or attend education or training for employment, or because the parent is disabled or ill. Health-related expenses that are not covered by insurance, or the cost of that insurance, and post-secondary education expenses. There are some considerations such as the necessity and affordability of the expense, but generally these expenses are shared. Extraordinary expenses relate to extracurricular activities, private school, and other educational expenses, if they relate to a child having particular skills or needs and they cannot be covered by base support. So something like house league hockey would not be an extra expense, but rec hockey, because the child is talented enough to merit the extra expense, are shared. Swimming lessons are not extraordinary expenses. Swim team at a higher elite level is. Private school is not usually shared unless the parents agree to private school or it is necessary to meet a child's particular needs. Some things like birthday presents and vacations are never a special or an extraordinary expense because they do not meet the definition in the Child Support Guidelines. But parents can share them if they agree. Not taking tax deductions, subsidies, and other benefits off Section 7 expenses. A common mistake that separated parents make is to get a receipt from the other parent for an expense and hand over the money for half of it or whatever the parent's proportionate share is. Section 7.3 of the guidelines says that any subsidies, benefits, income tax deductions, or credits related to the expense must come off the amount to be shared. That is because the parent who paid the expense is not actually out of pocket the total amount of the receipt. This is a bigger one for daycare medical expenses where there are clear tax savings that have to be shared. But if the child's participation in a sport or anything else is being subsidized, or the child is getting a scholarship, it is only the amount that the parent actually pays, not the total cost that the parents share. So a parent who is paying his or her share of expenses must inquire whether the other parent is getting reimbursed for any part of that expense. Setting off support payments. In shared and split parenting situations, both parents are responsible for child support. Often, when both parents are supposed to pay support, they set off the amount so the parent with the higher income or the one who owes more just deducts what the other parent owes him or her. That makes a lot of sense, and it keeps things simple. But a tax court ruling says that only a parent who receives child support can claim tax benefits for the child or children. Where the parent set off support so that only one pays, that paying parent loses access to tax benefits. For both parents to get the tax benefits, they both have to pay support to each other. This is stupid, but if the CRA finds out that parents have been setting off support, the support-paying parent can end up with a whopping tax bill. The FRO takes care of accounting for parents who owe each other money when it is involved. But if parents who are in shared or split custody situation need to remember this one to avoid tax trouble. If you have found all these tips helpful or informative, remember there are about 100 other episodes so far. So hit subscribe to make sure you get them. Hit the like button to help us make more, and click the notification bell to find out as soon as new episodes come out. In addition, if you are finding family or children's law confusing or difficult, or you just need to understand it better, or you need to know how best to make parenting work after separation, or if you need to understand how finances work during a marriage or common law relationship and after separation or divorce, get the latest edition of my book, The Guide to the Basics of Ontario Family Law. You can access it immediately on the iBookstore, on Amazon for the Kindle version, and Amazon can deliver the paperback version directly to your doorstep. You can also get a lot more Ontario family law information on www.schumanlaw.ca. Not only are there hundreds of pages of family law information and links, but there are links to get my book and links to reach my office to meet with either me or one of my colleagues. You can also contact us to make an appointment to speak to us using the contact information in the description. It is always best to get a lawyer who can give you expert advice that is specific to your situation. In addition to my website, keep up to date on family and children's law issues by liking my Facebook page, following me on Twitter or X and Mastodon at @SchumanFamLaw, and finding me on LinkedIn. I'm also on Threads. Of course, please subscribe to my YouTube channel and hit the notification bell to keep up to date. You can get the audio versions of the Ontario Family Law podcast on all major podcast services, including Apple Podcasts, Spotify, Google Podcasts, Amazon Music, and many more. Or you can get all the episodes at www.schumanlaw.ca. Just look for podcasts in the drop-down menu. Thanks for participating in this podcast. We will get together again soon.